And now what I'd like to do, in the order of the presentations, is to invite both of our speakers to just summarize what they think the key takeaways are for this event. So let's begin with Erin Dunstan. Erin?
Sure. So I think, as we mentioned, PGRs have that really tough deadline of 9 months after issuance. So as a potential petitioner, just really be aware of that. That will go quite quickly, so try and get your house in order and try and get drafts done as early as possible. Also, because of the workload at the PTAB, whereas it used to take a day or two to get your notice that you have a filing date, it can take up to a month now. So don't cut it too close on that 9 months deadline. Take that into account and file early enough such that if, gosh forbid, you had to correct something, you'll have time to do that. Also, again, I can't stress enough in view of the not only Rule 36 affirmances, but the affirmance rate overall, take the time at the board very seriously and put your best foot forward.
Thank you, Erin. And now, Dr. Kerry Taylor, take a minute or two, please, for what you believe some key takeaways should be.
Thanks, Al. So one of probably the biggest for all three, the common thread of these topics, they've all been very fundamental topics for 2017, but they all have a wait-and-see component to them. In aqua products, we're still waiting to see how much this will empirically change ultimate outcomes with that shift in the burden. In the meantime, those who it's their only manner for proceeding, certainly they might have a better chance, but those who have the ability to wait and see and make decisions once more data come out, they would avail themselves well of that. Sovereign immunity has a lot of unresolved issues, again, for patent owners who need to find a source of protection now. They can take the chances. It's hard to quantitate what that risk is or is not, but this might be their best way to survive. And so if there's a possibility of getting success, maybe one would go that way. If you're not yet under the gun, this is something to watch very carefully, because depending on the exact nature of each of these nuances, it could be something that nearly completely eliminates PTAB proceedings, or it could be something that essentially is relegated to exceptional and rare circumstances. And finally, with oil states, this is again a possibility where all PTAB proceedings could go away. Or it could be life as usual. Those who have to make decisions, particularly petitioners who have to operate under a strict time frame, probably should continue to operate status quo, but those who have the ability may want to wait and see the ultimate developments before taking action.